Hi, how are you? How are you? Yeah, we can get started. Thank you.
Thank you all. Thank you all. All right, thank you all for being here. We really appreciate it. Looking forward to this conversation. It sounds like there's been already some discussion around the governance of ICOs and cryptocurrencies, and I think we have more to talk about, maybe dive a little bit deeper on some of these things. But first and foremost, maybe we'll do quick introductions. I'll start off real quickly. So I'm Joe Raczynski. I'm with Thomson Reuters. I'm a technologist, which means that I primarily deal with a lot of emerging technologies. So I've spent a lot of time on AI, analytics, virtual personal assistants, bots, things like that. And I've been in the blockchain space, I guess, more or less since 2011, when I was unfortunately positively and negatively affected by some things going on with Bitcoin way back when, which I'll get into in a bit.
Good morning, everyone. Ken Chagwin, Republic. I run an investment platform that connects startup and blockchain projects to accredited and non-accredited people around the world. So we really promote inclusion in tech and inclusion in blockchain. And there got to be a way, even as tokens move toward the securities route, for everyday people, students and doctors and floors to participate and bring open participation back to blockchain in general.
Caitlin Long, spent 22 years on Wall Street, most recently ran Morgan Stanley's pension business, have a couple of degrees from this esteemed institution, so it's good to be back. And most recently, after having spent 18 months at Symbiont, which is an enterprise blockchain company working on the Vanguard project, I went to Wyoming, which is my native state, and got 5 blockchain bills passed, including the world's first explicit recognition in the law of utility token.
Hi, I'm Anil Bani. I'm a corporate lawyer. I've been practicing in Silicon Valley since 1999. I call myself a startup lawyer because that's really all I do. I present startup companies, technology, high-growth companies. And many of our clients recently have gone into blockchain. They're developing products, technologies for blockchain. So that's how I got involved. We've had some clients that have done ICOs, and many of our clients are building blockchain products. As you can tell from the way I'm overdressed today, but I do promise to make up for it if they would allow me to start, as long as again you promise there's no one from the SEC here. I promise to make some controversial comments on the Harvey test when we get there.
Perfect. No, sounds great. Looking forward to this.
There are switches on top of your mics.
Gotcha.
There you go.
Great. Are we good? Okay. All right. So sometimes I think we need to take a step back and say, what in the world? We are going through amazing times, something like I've never seen before. If you told me in 2011, 2012 that we'd be talking about this at this point in time, I'd say no way. Absolutely no way. The last 12 months in particular have been fascinating, absolutely fascinating. The idea that people are raising money left and right, as we've seen, millions and millions of dollars very quickly. The idea that you can actually launch an ICO in about 90 minutes, in all honesty. You can code it up. I can code it up in about 90 minutes. You need to create the white paper, of course. You need to have the website. But that's how easy it is to do these things. Now, that's both positive and sometimes negative. There's a lot of challenges there. Because it is so easy to do, what can you possibly do with this? How should we actually start handling this? Of course, we're seeing governments across the world starting to try to figure this out. Our government in particular is trying to help with this too. So I think first taking a step back from this and thinking about this a little bit more, maybe we need to do some more definitions around this. We've talked a little bit about it already, but let's get into it first, talking about the utility tokens versus security tokens at this point. Would anybody like to jump in and talk a little more definition around that?
Well, maybe I'll start because Wyoming defined it in the law, and the utility token under the Wyoming law has a consumptive purpose, which means it's exchangeable for goods or services or content. And the critical aspect of the way the Wyoming utility token bill works is that it cannot be sold, cannot be marketed as an investment.
I guess I'll go next. I'll take Jay Clayton's recent sort of description. If you're running a laundromat, you have a utility, if you're raising capital, it's a security. I don't know if I necessarily agree or where he was getting at, and we'll go more into that, but basically it's a utility token if you're using it for like a prepaid service or allowing, if your product is on blockchain and it allows your customers to access your product and services. It's a security token if you are using that to raise capital, and then Ken can go into details about how that happens, and therefore it somewhat falls within securities laws, and you have to sort of look at that route.
There are a few tokens out there that are straight up securities, meaning there's little doubt, black and white, that is any token that would give you economic interest in the underlying company. If they make $100 million, they're $100 million token, they give you back each $1 per token in profit. That type of tokens are generally deemed to be securities token. Outside of that landscape, I think the question of utility and securities is almost moot to debate at this point because the law, the SEC has second to the last say. The court system actually has the last say, and I don't think we're going to see any clarity on that this year, at least at the federal level. And I think that there's a misconception on focusing on the token itself. Rather, the question is the offering of token is that an offering of securities. Separating the securities, the underlying tokens and the offering, I think in the long run you're going to see that track being litigated in court, and I would hope that a lot more tokens are actually going to be deemed non-securities than what the law firms are currently suggesting.
There was a point made in the earlier panel, which I think is really important to take home, which is that most of the platforms are not functional yet. And so the rubber won't really meet the road until the platforms are functional, which means that the token is actually exchangeable for a good or service or content. And that's when I think you will start to see the testing of these definitions. That is a distinction that was made in the Wyoming law. We originally had it drafted much more broadly, and then the securities industry came in at the end and forced us to narrow it down, which at first made me angry, but actually as I look at it, it's a lot closer to federal law, and I think it's going to stand up to scrutiny. It essentially means you cannot market your token as an investment, and there are standards under the Wyoming law that you should read that help you identify that that is not the case. One of them is that if the platform is not yet operating, that you cannot allow your token to be exchanged. So it is in that regard somewhat consistent with some of the security standards that lock up the security for a certain period of time and prevent it from being exchanged.
Great point. Did you want to say something?
Yeah, the only point that I'm trying to make is that, as Professor Yermak pointed out in one of his slides, there's actually no action letter exempting a parallel version in the sports world, people buying tickets at a stadium before the stadium has been built. And those things are traded and sold in a way that hasn't been deemed to be securities. So you can't just take out an asset class due to a lot of attention around the world and treat it or mistreat it differently.
Excellent.
I actually think that Chairman Clayton's statement that he's never seen an ICO that wasn't a security is not inconsistent with the statement that all ICOs are not securities. And that may seem like a contradiction, but what's missing is the nuance, and I'm so glad that he 2 days ago took the opportunity to explain that a token can change its stripes, because the distinction that was missing from that original statement was that there are two stages of virtually all of these platforms. There's the initial build stage, and then there's the operating stage where the token is actually exchangeable for goods or services or content. And in that initial build stage, almost certainly, to Ken's point, you are actually, what your token is likely to be a security. It's very difficult, especially if you marketed it as an investment. And by the way, one thing to be careful of, we're again and again from the previous panel, I'll reiterate it. This is not legal advice, and you should go get your own competent legal counsel who's very sophisticated in these issues to advise you. If you're out there talking about your token offering on a Telegram channel or on Twitter, the SEC might deem that to be marketing the security. So just be very careful. There are lots of landmines that you can fall into, and it's very easy to trip over these wires. You need to make sure that you're talking to a competent counsel who reviews what you're saying publicly about your token offering to be sure that you don't trip over it and have it inadvertently become a security. But in that first stage, it is likely that it is a security under federal law. And that second stage, to my point, I can't reiterate that enough, that's when the rubber's going to meet the road. That's why Chairman Clayton's statement might actually be true, that every ICO we've seen so far is a security, because very few platforms are yet operating and actually exchangeable for goods or services. We'll see when those platforms become operable, whether he acknowledges that those tokens are either no longer securities, or more likely that the cleaner way to do it is explicitly offer traditional securities in a Reg A Plus or Reg CF or Reg D offering in the first stage of your platform, and then do your token generation event once the platform is actually operating. That's a lot cleaner from a federal securities law perspective.
And I know we have to move on to other topics, but I just want to close this discussion, but this one at least, by saying that the challenge is, right, there's no clarity from the SEC on the rules. And again, not to bring another controversial topic here, but Jay Clayton, making these offhand remarks is like Trump running his foreign policy on Twitter, right? I mean, you have to decipher what it really means and what you can and cannot do, or what's happening in the real world. So I think what we need is more clarity, and SEC to come out and be transparent about what they're looking at. Do they have an in-house, do they have a special committee designated to define what a utility token will look like or should look like? Are they getting public feedback from the people that are actually building these products? That's the kind of exchange and sort of inputs we need from the SEC.
Well said, well said. So, Keelan, you mentioned marketing. You started talking about marketing, and obviously we're not giving any advice to anyone, of course, but what is it that we need to sort of consider or be worried about or conscious of? Because if I get probably 10 to 15 different ICO emails a day in my inbox, and they're just broadcasting constantly, like, hey, invest, but that seems like that might be counter.
Yes. And again, this is where the lawyers need to review, because it does depend on, if you are taking advantage of securities law exemptions, the standards are different. You can, if you're going to accredited investors only, say a lot more than you can say if you're doing Reg A Plus or Reg CF offerings. And maybe we can go into detail. You probably are the best positioned person on the panel to go into detail about what those different requirements are. But if you promise a return, or you say anything that implies this is an investment, even if you have a purely consumptive purpose utility token in your platform, you fall into that securities bucket. So the manner of sale, it's the Howey test, the 4 prongs of the Howey test, but it's also the manner of sale, how you're talking about your token, whether you're implying that its value is going to go up over time because of scarcity or because of tokenomics, or however you set it up. You really can't say anything about future value at all if you want to avoid securities classification.
Any thoughts, Kendrick, on that?
Yeah, no, I mean, just to harp back to what Caitlin and Andy Bromberg said early on, if you're going to do an ICO, doesn't matter if your token, securities, utilities, no one knows, get very good lawyers. In fact, get a couple of them, and then cross-check their opinions. Maybe on different coasts, different people have slightly different takes as well. That's just the cost of doing business, to make sure that you stay out federal prison should that falls on the wrong side.
And Noah, anything you want to talk about?
No, I think I echo that. Get good counsel. I would just reiterate that this is not complicated, right? I mean, they have I keep saying this, private companies have been raising capital for the last 40, 50 years. There are laws and regulations that allow you to do that. You just need to understand what your purpose is, how to structure it within those laws, find an exemption, or I guess wait for clarity on utility tokens.
Excellent.
And in the meantime, set up your business in Wyoming. and I'll tell you why. I'll tell you why. In addition to the utility token law, which you can avail yourselves of if you are setting up your platform in the United States, Wyoming LLCs offer tremendous privacy. You don't have to disclose to the Secretary of State anyone who, other than the managing member of the LLC. So if you've got other business partners coming in, you don't have to disclose that. And there's also no tax. There's no corporate tax, there's no franchise tax, there's no gross receipts tax, and there's no property tax on crypto. And there's no income tax, both personal and corporate, in Wyoming, right? So there is no information for the state tax authority to collect and share with the IRS. So as you think about setting up your business, the first decision you need to make is actually not a federal decision. It's where are you setting up your business within the United States? And it's very clear there's one state that has made a big play, which is my native state. I don't even live there. But it truly is the friendliest, and it takes away some of the state issues that can bite you later.
I just want to add to the Wyoming. I think it's a great, I appreciate, all the initiatives. I don't know if you consider paid endorsement or not.
No, it's purely volunteer, by the way.
I can tell you that I've practiced for over 20 years. I have never heard a client ask about Wyoming until now. It's always been Delaware or California.
Yeah.
Obviously, everyone's now it's on the radar.
Yeah.
The only thing I would caution, sorry not to burst your bubble, but the only thing I would caution is like marijuana, right? You can set up a marijuana business in California, but you're still violating federal laws. So you have to be careful that you could do your ICOs and perhaps be in compliance with state laws, but you still have to deal with federal laws. So just keep that in mind. Again, I didn't want to burst.
No, it's 100% true. It doesn't burst the bubble at all. If you think you have a utility token, let's say you think it's going to take you 18 months to build your platform, where you should set up your company matters. Where you set up your company now matters a lot, because if you have a state that explicitly recognizes that what you're doing is legal, you know exactly what standards you have to meet. And in the first 18 months, you probably will sell traditional private placement securities, Reg CF, Reg A+, Reg D. But when you do your token generation event, say 18 months down the road, you want to be in a place that you know that it is explicitly legal, and that's the benefit of having protection like that.
Still get a good lawyer. I just want to make sure.
100%. Yeah.
Our business, just making sure.
No. And by the way, I'm not a practicing lawyer. My Wyoming work is purely voluntary. I did it as a service project, both to my home state, but also to the industry, to try to give some clarity. And I didn't expect that we were going to be as successful as we were. I was hoping we'd get one of the 5 bills passed, and we ended up getting all 5 of them passed, 2 of them unanimously, all of them with very wide margins. So it definitely is something that the industry should pay attention to. You mentioned Delaware, California, some of the places where traditionally businesses have been set up. Delaware they've got a franchise tax that will sting you. It looks like it's cheap to set up a business, but then you have to start paying annual franchise taxes. Nevada's another place where it looks like it's a friendly place to set up business, and they're making a lot of crypto advances in the state, but they've got a gross receipts tax. So all of a sudden, the tax stuff that starts to become complicated, and you have to start paying a lot more bills. That's why paying attention to the state decision matters.
Maybe we should have a separate panel on setting up in Wyoming.
So a minute ago, I think you mentioned something about privacy. So I'm curious to get your perspectives on when we get to privacy coins or privacy tokens, which are completely anonymous for the most part. There's been something that came out recently with Monero, which is one of these tokens, that is, you could sort of trace it a little bit if you go back to an earlier build of the token itself. But where are you all seeing the landscape for this? I mean, is it something that there's governance that's coming around this space? Is it something you see the federal government in terms of AML issues around that?
In connection with ICOs?
Yes.
Everything else aside, that is a concern, right? Because the ability to raise capital from these undetermined sources, especially in cryptocurrency from across the world, there is a high risk of misuse by all sorts of, people. And that area, I think, more than securities, more than the utility versus security tokens, I think that is an area that could hold up. So the industry itself has to come up with solutions, AML, proper diligence, to find a way that, it doesn't become an area where the regulatory authorities, governments can crack down on these ICO offerings. It's a big issue, though.
Unit one token is truly anonymous, just the US dollar, right? You take it, you hand it to someone else, and the person hands it off. So in small amount, that's not going to be an issue. The moment that you transfer or trade in a large amount, obviously to the extent that a token is deemed to be securities, and even if not, you have these exchanges. And so soon enough, they already have increasing regulations for all different agencies on various exchanges on their obligation to know your customer, anti-money laundering, and so on. And so I don't think it's going to be a major issue.
Ken, as much as I'm on your side of the table, the difference in the dollar, you can trace the source of funds. At some point, you can trace it. In a lot of these other transactions, cryptocurrencies, it's not as easy to trace the source of funds.
No, I mean, like if a single dollar that I hold and then I use it to buy, I don't know, a banh mi or whatever, and then people use it. If you just use cash, physical cash,
but parents are not going around using physical cash, right? I'm just talking about
small amount, okay, you do it, right? Of course, yeah.
So along those lines, in terms of tracking and AML and pieces like that, we also have exchanges. So Coinbase, I think in the last 24 hours, is now in negotiations with the SEC to actually start to work towards becoming a classified group, that they're actually going to be certified. We'll see what happens with that. But there are also exchanges around the world that are decentralized. So if you ever used, and don't admit it, if you ever used any of those torrents from years past, they're actually decentralized exchanges. So at some point, it kind of defeats the whole purpose to go through Coinbase or any of the other 140 that are out there, because those are central locations that can be hacked or whatever. So we're going to get to a point where we're going to have these decentralized exchanges. Now, do you have any thoughts, any theories on how we could even potentially regulate that? Is there going to be any regulation in that space whatsoever? It's a tough question, but I'm just kind of curious to hear.
Yeah, I mean, yes, I mean, and we don't have the decentralized exchanges right now that we can look at publicly available that you can, use and admit to publicly. So I would expect as the volume increases, there will be regulation, especially, and I think there was reference to taxes, right? So disclosures on these transactions for tax purposes certainly will need to be looked at and increased. But the other reason these decentralized exchanges are good is because, and the development is a positive development, is because they also allow for an exit, right? I mean, that's one of the things we haven't talked about in ICOs. You issue all these tokens, or companies issue these tokens and raise money, but what happens to the investors? How do they get an exit? Unlike, other traditional sources where you buy shares and you can, as the company lists publicly. So they would allow for a larger of the security tokens, at least, to be listed or exited and transacted. So that's the good news, right? And there will be challenges on how to regulate and the tax implications.
So along the tax road, think about it, and I don't know if this was discussed earlier or not, but one of the things I think about is, let's say you have people who are mining, and there's really no cost basis for that, right? So they're just mining, they're using their own electricity, wherever that might be, Washington State or somewhere abroad. How do you think there's going to be the taxation of this, like for the ICOs, for anything that you're actually mining? Is there anything that you can think of that the governments will start to put in place, even in Wyoming? So where's the tax basis for that, do you think?
Well, Wyoming doesn't have tax. They do have sales tax.
Okay.
But it's pretty clear for the miners in Wyoming that doesn't apply because they're not selling anything. So that's another reason why we're seeing miners congregate in the state. But the federal taxation is definitely a gray area. Anybody who's gone through to getting ready to file your taxes this year understands, how are hard forks taxed? There's no guidance. Airdrops, no guidance. Is that income in 2017 with your Bitcoin Cash and Bitcoin Gold, or is that like a stock split where you ended up with an asset that happens to have zero cost basis and you realize and pay taxes on it when you sell the asset. The other challenge for issuers of tokens is that a taxable event for the company? Again, this is where paying attention to where you set your business up matters a lot, because you can have a franchise tax show up that you didn't anticipate and factor into your model. It does really matter to do that planning in advance. But this is clear as mud. It's about as clear on some of those complex tax issues as the complex security versus utility token issues. It is going to require legislation, and I hope it doesn't come out in litigation. The way that, as a non-practicing attorney, the way the government tends to go after enforcement cases, both IRS and SEC and other regulatory agencies, is to go after ones who are not likely to be able to fight back. In other words, not deep-pocketed. Basically, if you look at the enforcement actions that have been taken, basically everybody caved. Nobody's litigating. And that's not an accident. I do think regulatorily, it's just not possible for every single fraud or scam to be enforced by the SEC. So they go after the obvious ones as a means by which to set policy and set precedent and give guidance to attorneys. But notice that there hasn't been a single case yet that's been fought. And I think that's not an accident. They go after folks that are not likely, not well positioned to fight.
I think there is a dichotomy between taxes and the description of the issuance as a security, right? And that's the IRS and SEC sort of traditional friction at play. If you talk about miners, right? I mean, the actual miners. So there's the tax element there, but also the tax element on the transactions itself, where the companies are issuing, right? And that has been litigated in some respects. Coinbase went through the implications of having to disclose these for tax purposes to IRS. They went to litigation. They ended up settling somewhat, agreeing to certain, disclosing certain transactions, but not the others. So that's still in process, but there has been some precedent already. And I think we will have our Miranda or our Howie for the ICOs at some point, right? And some moron's going to screw it up, and it will get litigated. On the miner side, I'd say the position I would like to take is like any other, in our startup world, right, where advisors and consultants and developers provide services and get stock or options. They aren't and shouldn't be taxed until they sell and get proceeds, right? So we should apply the same test from the IRS perspective. So if you're getting these coins in exchange for your mining services, you shouldn't be taxed at that time. You should be taxed when you convert these into whatever other currencies where they're subject to tax. That's what I mean. Obviously, it's not advice and certainly not tax advice, but that's how I would like to look at it.
Anything else, Kendrick, on that?
Nope, I don't.
Okay, fair enough. So maybe going from the U.S. to abroad, we see almost every day there's changes across the globe in terms of what people are looking at, what governments are looking at. China at one point is like, absolutely not. We do not want to have any ICOs here, and then all of a sudden they're yes, they're no, they're back and forth. Same thing in South Korea. There are some governments that are open to it, some that are not. You've seen the full spectrum. I'd love to hear your perspectives on, the countries that are probably more welcoming versus the ones that are less, and do you think there's going to be any changes in that landscape?
Yeah, surely there. Of course, I mean, every aspect of the entire ecosystem will change drastically. At least that's my expectation. But I think it's interesting to know that the second wealthiest and most powerful country on earth, China, banned crypto trading, and that didn't stop it, right? We track and we see investment from China and Chinese resident into the U.S. in a major way. And, part of the reason is that until now, in order to move $10 million in cash out of China, you need several levels of governmental approval. And 2017, exactly. I mean, I don't even know how many tens of billions had been traded in and out of China under crypto assets. So that's why the Chinese government, put a stop or tried to put a stop to it. That's not going to stop this technology or industry. I think it's here to last. And it just, if one block, it's just like a water stream, it finds another way to move.
I dug out an email. One of the things that that happened with the Wyoming Blockchain Coalition is we were deluged with inquiries, and a lot of them were something similar to this. I'll read this to you, keeping the sender's identity anonymous. I wanted to say thank you for all that you do in blockchain, as my company has been the victim of slow policy changes within the U.S. government. We're looking to start our company outside of the United States, and that just never seems to sit well with two red-blooded Americans leaving because of a simple definition of a utility token. I was hoping it may be possible to speak with you, blah, blah, blah. We are almost ready to launch and want to exhaust every possible avenue to keep the revenue in this country. So, and it is unfortunate, but there are other countries, not necessarily tax havens. Certainly there are those like Gibraltar and Cayman that are more friendly than U.S. laws, but Switzerland is a very respected jurisdiction, and it is a lot more friendly to this industry than the U.S. is. So it's a fact, and it's a sad fact. I know that the policymakers in Washington, well, the SEC, this kind of argument lands like a thud. They look at it and say, your job, if you don't like the laws, is to go to Congress and get them changed. And that's the sad truth.
Let me add my perspective. One of the things I do is really go around the world and talk to entrepreneurs, really, in some cases, push them to look at incorporating in Delaware. I can tell you it's becoming more difficult. It's just a challenge that a lot of these questions are being asked. Entrepreneurs across the world are asking me questions about Reg D, Reg S, and they have their hands on their heads and say, it's fucking complicated. It's just, we don't know US was complicated. I ran from India practicing law to come here because it's easy and you can build companies, and we're going in a completely different direction. It's that challenge. Speaking about Switzerland, again, a very practical perspective, Switzerland, keep in mind, historically they've made money, one of the highest per capita, in the world. They make money by milking cows, selling milk or chocolates, or taking other people's money, right? Those are the big, and some tourism, right? So they realize that because of the crackdown by US, India, China, all these big governments, they can't really keep holding on and making money from other people's money. So they say, wait a minute, there's one thing we know is finance, and we have the infrastructure. We'll use that here, and they will become the next big hub. And that's where the pressure will start coming up. The politicians here will see the flight of capital. India, China, all these countries will see that their entrepreneurs, their investors are investing in Swiss companies. All the taxes, even if it's 8.5%, it adds up, are now relocating to Switzerland. That's where we'll see more action, more pressure on regulatory authorities to come up with clear rules itself.
So back in the U.S., what does the regulatory landscape look like going forward? How long is it going to take before we even get to a point where we feel a little more solid about some of this? Any opinions on that?
Definitely not in 2018.
Yeah, I think that it is going to require some congressional action, and the Wyoming project was a one-off project for me. I've been asked by more than a dozen states to get involved in their projects, and it's not something I want to do, in part because it was the most intense project I've ever done, and I'm just exhausted from it. But I will go down to Washington and work with the Congressional Blockchain Caucus, because that email I just read you, I have dozens of those, and the policymakers need to understand, if someone's reaching out to try to comply with U.S. law, they're not likely the companies that they're not likely to be fraudsters. They're not likely the companies that we want to be pushing out of the United States. And the policymakers need to hear this. And it wasn't until I went to a government blockchain conference last week and heard the SEC blockchain head come out with a very strong message. I thought, I just need to publish all these and anonymize them so folks understand we're losing businesses in the United States, and I do not think that that is what we want. I don't know that every one of these that contacted us was a legitimate business. We all know that the majority of startups fail. We all know that in this sector, a majority, an even bigger percentage, are going to fail. But there are some gems that I'm sure we're sending off to Switzerland, and once they're gone, they're probably not coming back.
Yes, and it's not just the companies, the entrepreneurs, the investors that are investing, they will all start looking out. And I think in terms of timing, I have no idea. But I would again, look at the analogy of what happened in the marijuana industry. I mean, for 10 years we've been thinking it would become legalized on a federal level, but what happened instead is each state started looking at, most states in the US, the large states are broke, right, financially. So they're looking at this potential tax base. And the states will be faster. Wyoming is a good lead, but California, New York, other states hopefully will follow and start developing rules to allow for these, and there'll still be this challenge and conflict with federal securities laws. I think the pressure will come in the next few years from all this capital leaving the country, but not until then.
I think I have a slightly less pessimistic, contrarian view about the U.S. ecosystem. I think we live here in the U.S. and we sometimes forget the gravitational pull. And yes, there are challenges, but let's say securities as an example. Even if you set up shop in, say, Switzerland and hire a team there and build a project, unless you plan to not ever have a single token leak into the hand of a U.S. resident, the U.S. SEC has jurisdiction over you. On taxes, forget about the fact that if you're, let's say right now, if I were to somehow set up a new company, want to take advantage of the tax benefits of Switzerland, move there, set up a team there. Even then, if this U.S. effective collected income and the last tax bill introduced by the Trump administration also reduced that advantage significantly, weighing all of that as a business person, the value of accessing the U.S. market, if you're building a legitimate multi-billion and potentially trillion-dollar business, you're not going to flee to China or Switzerland or Singapore anytime soon. But that's my view.
I would agree with that. I wouldn't say that you would flee, but there are also businesses, and we have to acknowledge there are businesses being built outside the U.S. that would otherwise be looking to come to the U.S. to access capital that are not looking at U.S. as attractive. I mean, there's a comparison as such.
Yeah.
Kendrick, what are you advising your clients, your customers about this? I mean, you always saying, do what you can in the U.S. You're saying, maybe try something else, somewhere else.
So a lot of people or projects we work with are among the more credible, well-funded, experienced projects. And, those who aren't within the categories, very easy to advise, just do your homework and do what you should do to get to a level where you should be looking at fundraising this amount of money. But for those that have the resource, the capital, the access, really, I think one law firm is never enough. I've been involved with, projects like Filecoin or Blockstack from back when, and without naming any one particular lawyer or one particular law firm, from the outside looking in, it was incredible how sometimes information or incorrect or misinformed advice was delivered by one attorney, and perhaps his partner sitting in the same law firm just down the hall may have the key to that answer. So, consult like 8 times over to make sure that, you weigh people's idea, and people who are doing this are very smart. You can make a decision and for your own, how to consolidate that information. Just spend a lot of time with as many lawyers as possible.
I'll give you one example. In some of the SAFT agreements that I've seen, the initial purchaser is required to certify that the sole reason they're purchasing is as an investment. If you've had your purchaser certify that the sole reason that they're purchasing is as an investment, that makes it a lot harder for that token to change its stripes to become a non-security, right? So those sorts of things, this is where you can trip up, and that's why I think that for those that are likely that want to sell to U.S. investors and want to stay in the United States, that strategy of using a securities exemption, not doing a token generation event until later, and then if you're doing it in a state that acknowledges token generation events that are legal,
state would that be?
Which state? One state. Then it's a lot easier to comply. And like you, Kendrick, I'm not as pessimistic as it sounds. Again, when I said earlier, I don't think those two statements are inconsistent. That all ICOs, that Chairman Simon Clayton has seen have been securities, and that not all ICOs are securities. Those two statements sound inconsistent, but they're not. It all has to do with the timing. Are you talking about a stage 1 token where the platform's not built yet, or a stage 2 token where the platform is functioning and actually, and the token is actually exchangeable for goods and services? Totally different analyses.
I want to repeat what Ken said, spend as much time as many lawyers as possible. I mean, if that doesn't make you feel warm and fuzzy, then I'd like it on a Saturday. So, or hope and take action so that the rules become clearer, it's easier, and the clear track for being able to, for companies and businesses to issue utility tokens using blockchain, which the technology already exists.
Excellent advice. All right, I think we might jump to some questions.
Thank you, panel. So we have a question for Caitlin, and I think for the whole panel as well. How can we encourage Wyoming's blockchain legislation to expand to other states?
The community's doing that. Like I said, about a dozen states have reached out to us. The state circumstances are going to be very different, but the advice that I've been giving is, if any of you read are fans of Malcolm Gladwell like I am, he talks about successful projects having salesmen, mavens, and connectors. We had a great salesman who was very well respected, an accountant in Cheyenne who had no enemies, who was the executive director of the Wyoming Blockchain Coalition. I was the maven, so we had somebody from the industry who knew a lot and could speak with credibility and help and literally talk to every legislator one-on-one and get them up to speed, get them comfortable. And then a connector. And this person literally knew everybody, and he's the one who brought the legislator, Tyler Lindholm, to the table, and that's how we got it done. And Tyler, lots of folks have been reaching out on our Telegram channel. By the way, we do have a Wyoming Blockchain Telegram channel, and it's open. Anyone can join it. Lots of folks have been reaching out to Tyler, and he's saying, look, I'm a Wyoming partisan. I'm not going to help with other states. I wish you all well. But I think that's the best advice. Go find your trifecta of salesman, maven, and connector in your state and get it done. This was a service project. Rob Jennings and I both grew up in Wyoming, but neither one of us lived there. We just camped out in Cheyenne the entire month of February and just, like I said, it was the most intense project I've ever worked on. We got it done. That's what it takes. If we'd been paid lobbyists, we would have charged millions and millions of dollars for the hours that we put into this. But if any of you have the ability to do this in your career, I would highly encourage you to do it. It was a community-driven effort, organic. That's part of the reason why the legislators loved us. We weren't asking for anything other than enabling legislation. We cost the taxpayers of Wyoming nothing, and we're going to be bringing revenues into the state. It was a really great situation. You will find those situations in your states, and I would encourage you to do it.
So have there been any efforts within the industry to self-regulate? Perhaps a cohesion of groups or different exchanges coming together to sort of talk it through?
There's been talks and discussions about, governance, SROs for the industry. I think it's way too early. We're at like pre-dawn of this new ecosystem, and the dust, you just gotta wait unless the dust settles. And influencers in the space, may it be entities like Coinlist or coincenter.org, they using their market position may impose a certain standards, but I think the effort that otherwise would go to trying to set up an SROs is probably best deployed to a legislative effort or just, do the right thing and voice that opinion.
Yeah, I would say yes. Efforts. Coinlist is a great example. And businesses are using technology to make it easier to validate and verify and, track these transactions and even report to the IRS as needed. But again, it has to be a balance between the industry self-regulation and clarity of rules. I'll keep saying that,
There's an organization that formed in Wyoming that's a global organization called the Digital Asset Trade Association that came in at the end and formed and helped us, and they're now working in Colorado. Their a group. They're West Coast sponsored, so it's funny that there's a big difference between the West and East Coast. I feel like the coasts in this industry don't talk to each other. So they're primarily West Coast money, but they're going into other states. And they have a token curated registry that they're looking to use as a way for the industry to upvote. And I know Ryan Selkis is also working on one of these as well, for the industry to upvote who's legitimate versus who's not. And I think that would be helpful.
Wonderful. I think we're going to have to leave it there. Well, thank you so much to the panel. That was awesome. Really appreciate it. Thank you.